Welcome to High Stakes Criminal Defense Podcast.
Welcome to the High Stakes Criminal Defense Podcast with attorney Jeremy Babich of Levine, Flier and Flier in California. When freedom, reputation, and a lifetime of hard work are on the line, the person you choose to stand beside you in court is one of the most important decisions you will ever make. Jeremy focuses on high exposure criminal defense representing clients in serious felony and complex cases where strategy, preparation, and courtroom performance matter most. I'm LeAnn Lyon, and today we are talking about how jury trials in California actually work and how defense strategy can shape the outcome. It's good to see you again, Jeremy.
Thanks, Leanne. Always great to see you as well.
Jeremy, when a case is headed towards a jury trial in California, what are you evaluating first as you begin shaping your defense strategy?
That's a very interesting question. So, for me, jury selection arguably might be the most important part of a trial. And when you are selecting a jury, what you want to do is start to think of what your theory of the case is going to be. And once you start developing that theory of the case, you want to start trying to think of what the jurors might be trying to answer when they go back to that deliberation room after both sides have rested and both closing arguments are complete. Because if you can get that answer to what they are looking for and trying to figure out whether or not that's enough to support of the burden beyond a reasonable doubt, that you are trying to make sure that you have put a little bit of crack in all those bricks that the prosecution were trying to build to shape up that burden. And you are trying to get any way to put a little bit of a crack in it because all you need is one technically to get a hung jury. And this is the one job where you don't necessarily have to win, but you do not want to lose.
Interesting. So, what specifically are you looking for as you decide who should and shouldn't be on the jury to the extent that you can?
So obviously, it's a gut feeling a lot of the time, but what you want, and I believe both sides just want a fair juror, someone who's impartial before the case starts, someone who's willing to listen and give both sides a fair opportunity, someone who is going to listen to you when you are doing voir dire, which is very important, and make sure that they understand the basic principles of criminal law. And in so many instances, whether that's beyond the burden beyond a reasonable doubt, the burden of proof being on the prosecution, the fact that the defendant doesn't have to testify. You want to gauge all the potential prospective jurors and try to talk to them, try to first off get your personality out there as well, because in so many ways the defendant in so many criminal trials doesn't testify, so you are the person who is fighting for them on their behalf and connecting with the jury. So you want to be able to let your personality shine, let that connection seep through to the jurors while you are doing voir dire. In addition, you just want to make sure that you have jurors who are willing to follow the law and also are able to understand the basic principles of that criminal law.
So, it sounds to me then that once this jury is seated, must have to go back and kind of relook at the whole case from the point of view, from the defensive perspective, in light of who those jurors are. Is that right?
You definitely do. You have to really be able to, especially in opening. My big thing is you got to get your theory of the case out in opening statement. You want to put that out there immediately to give the jurors something to look for as the evidence is being presented. You want to get that out there as soon as the jury is seated and you are doing opening statements. Now, some judges might limit the time you have to do opening statements, so you have to be wise in how you use that time. However, it is vital for you to get that theory out there and give them something to look towards and also hold on to, especially once the case is done, for them to go back to the jury room and say, you know what, that defense attorney in opening told me that this was going to happen. And look, it did happen in the trial. And that's the reason that I don't believe that defendant is guilty beyond a reasonable doubt.
Wow. Okay. So when you are building that reasonable doubt, what kind of gaps or inconsistencies tend to matter the most for the jurors?
From my experience, it seems like, especially nowadays with technology and everything, jurors want corroborating evidence, whether it's scientific evidence, DNA, bullet, powder, fingerprints, anything that they can look towards, or whether it's phone evidence, because, phone evidence nowadays, cameras, it's all over the place. So it's why it makes it a very complicated thing to try to break that down little by little. But you, as a defense attorney, have to be so well versed in all of these areas that you technically become an expert in it as well. At least when an expert is put on the stand and testifying, you have to be able to cross examine them and really understand their field of expertise to give logical and cohesive questions to try to break down the prosecution's theory, whether it's trying to determine if the cell phone falls within a radius, whether you can't pinpoint an exact location. So I think the jurors are smart and they really do look towards that type of evidence to help support one side or another.
So, speaking of cross examination, I know that that can change how jurors view a witness. So, what are you trying to accomplish when you step into that moment?
Well, it's something that I learned early on that cross examination is essentially the linchpin of democracy. And the reason that it is because there are always two sides to a story. You get on direct, a witness tells their story. However, in many instances, especially if I hopefully get the case from the get go, there's already been a preliminary hearing. That witness has probably already given a statement to police. So you start using all those previous statements that they have made to first prepare for that witness and also be ready in case that witness then gets on the stand at the trial and starts changing their story. That's when it's so important to start impeaching that witness with prior statements that they've made, poking holes in their story, making sure that the jury hears the actual truth and not just what the witness gets on the stand and says that day. That, you know what? People's memory changes. People forget things as time goes on. And typically, most people understand that their memory is fresher, closer in time to the incident occurring. So when their statement is drastically different from what they originally said to what they then say at trial, it is vital and crucial for me to impeach them and make sure the jury hears that and really do not stop. You cannot stop when you are impeaching someone because you need to make sure that the jury hears, and you got to keep asking the questions, and you got to be able to think on your feet because in jury trials, I've experienced it many times, you don't necessarily get the answer that you were expecting. Sometimes a witness's memory changes, or sometimes who knows what their ulterior motive is as to why their statement has changed. But you have to be able to think on your feet.
Can you share an example of a time that your cross examination was fairly clearly the pivot point where everything changed for your client?
Well, you know what? It happens a lot in sex crimes cases too, when or there is a motive, financial motive as to why a witness's statement may change. In so many cases, especially sex crimes cases, when you are cross-examining the alleged victim, there are also so many other factors that a jury, because there are jury instructions where a juror is able to consider the bias and motive as to why a witness may testify to a certain thing. And financial bias is a crucial part of that. So when you are cross examining an alleged victim and the jury now becomes aware that that alleged victim also settled or had a huge lawsuit, whether it's against a school district, whether it's against a doctor, that plays a huge factor because money makes people do a lot of things that most people typically wouldn't do. But it's important for me to point that out to the jury so that they can consider everything and not just listen to what the witness says on direct examination, even if it's emotional, because in a lot of sex crime cases, it can get emotional and hard for a jury to listen to that. But when you paint the entire picture for them, that's when it can really change their perspective on the entire situation.
For sure. So, in serious felony trials, how important is timing, knowing when to push aggressively and when to maybe hold something back?
That's very interesting, and I can also relate that to cross-examining an alleged victim in a sex crimes case because you do want to come off as compassionate. You don't want the jury to think you're this aggressive, abrasive defense attorney who has no feelings and is going to just push and push and push. So you have to be very careful and delicate with how you approach that cross-examination. You also have to understand that emotions run high in a courtroom, whether it's sides of families who are sitting in the gallery. But you also have to make sure that the jury can see you, and also the jury gets that sense that you are just doing your job, but you're doing it in a very careful manner, a, a empathetic manner, a way that doesn't necessarily reflect poorly on you, because if it does, that's going to negatively affect your client, and that's ultimately who you are harming if you do come across as abrasive.
Yeah, I hear that. Jurors are often hearing very complicated facts and for the first time and without a law degree. So, how do you keep them focused on the issues that actually matter?
That's very interesting, and it kind of circles back to the theory of the case for me, and getting that out there and opening and making sure you hit hard on it in your closing arguments, kind of to bring it back full circle. You want to focus on the key issues, whether it's identity, whether it's lack of motive, whether it's a self-defense, heat of passion. You want to make sure you get your crucial defense out there from the get-go, and you harp on it, and you do not let the jurors forget throughout the trial. You focus your cross examination on issues or certain facts that support your theory, and present evidence, whether it's through exhibits or through expert testimony, that support your theory. So that's how you make sure that throughout the trial, because trials can be lengthy, there can be a lot of facts that come in through a trial that are superfluous, don't necessarily make a difference here and there, but a jury still is listening and has to listen. And you are trying to make sure you're gauging the jury as active listeners, seeing if they're taking notes down, all of these things. So it's crucial for you to continue to first start off with it in opening, and then make sure throughout the trial you are presenting the evidence that supports your theory.
So, during a trial, are there moments when you can start to sense how the jury is reacting to the defense?
It's interesting because as I've done trial after trial, I've started to understand that in a lot of the times you don't necessarily know what the jury is thinking. You try to look for signals, whether it's eye contact, whether it's note taking, whether it's a smile here and there. Like, no matter what it is, you try to harp on these little signs to try to think that, oh, you might have this juror on your side, but you don't ultimately know. And unfortunately, once again, into the deliberation room, it's so important on who the foreperson is and how that jury is run, and which jurors are followers, which ones are able to stand their ground and not compromise if they are put to that kind of a task. So, you really try to understand and go based on gut feelings a lot of the time, especially during jury selection. But ultimately, you don't necessarily know what they're thinking. They might like you, but they might think your client is guilty, or the other way around. And so you just don't have a real idea, but you try to gather a sense and try to focus and see which jurors are paying attention, which ones are listening to you, making eye contact, and taking down crucial notes when you are presenting certain evidence. So it's a little bit of trying to gauge everything and being aware of people's mannerisms, facial expressions, all of these things. You try to really look at all of the signs.
I sat on a jury trial and ended up being the 19-year-old foreperson in this trial. I pretty sure nobody saw that coming. Everybody else was just smarter than to, than to volunteer for that position. Pretty crazy. I think
Yeah.
everybody was very surprised when I was the one delivering the verdict at the end. But as we wrap up here today, when a case does go to verdict, what's usually makes the difference between a conviction and a not guilty outcome?
I think for you, as a defense attorney, you really need to attack the prosecution's case. You really have to harp on that burden being beyond a reasonable doubt, which also then has to leave the juror with an abiding conviction. You have to stress your theory. You have to give any reason for the jury to be on your side, because it is essentially, in a lot of my trials, my client's life at stake, where if they are convicted, they are going to jail for the rest of their lives. And so that's where that immense pressure comes in and is built in, especially when you know you have an innocent client. So you have to really show and give that jury a reason to vote not guilty. And I think that comes from you believing in your client's innocence. That belief that you give to the jury when you are delivering your closing argument is so important, because if the jury doesn't even believe you believe your client is innocent, then I think you are in real trouble. So that is where that stress and importance from your closing argument comes from, especially because as a defense attorney, the prosecution gets to rebut your closing argument and you can't rebut theirs after they finish. So you really have to take that one closing argument and really push your point of view through. And all it takes is one to be on your side to avoid that guilty conviction.
Well, thank you. And thank you to our audience as well for listening to the High Stakes Criminal Defense Podcast. When your freedom and reputation are on the line, understanding how the process works can make the difference. To learn more about Jeremy Babich and his approach to defending serious criminal cases, visit Levine, Flier and Flier.com. If you found this episode helpful, be sure to like, subscribe, and share it with someone who may benefit from this information. We'll see you next time. Thank you, Jeremy.
Thank you, LeAnn.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.